Good afternoon and good early evening. Respected Honorable Mr. Justice Kotiswar Singh, Honorable Justice Heman Mukherjee, Dama Shasatri Naidu, Senior Advocate, many of the senior advocates present here, members of the bar, and of course the representative of the EBC company here who has organized this function today. Indeed, it's an honor to come here, not really an expert in the field, but a journalist who has some ideas about this subject. But I thought still I would like to share a few thoughts which were in my mind when I was invited for this function. Commercial disputes is nothing new about this. There is nothing very new law. It has been there since ancient times. And you see also there is to be trade, there is to be businesses. India had a very robust business sense and also community in fact. They still exist and they are continuing their business activities since time immemorial and continuing till date. And at a time, earlier times also, this mediation and arbitration used to be the most effective way of dispute resolution. It continues. Unlike law like JJB, which brings a new shape of law to deal with this peculiar problem dealing with children, Commercial Courts Act 2015, though it appears to be a new act, is not really a kind of new law in this sense. So commercial disputes have been considered and decided as per the normal civil laws, CPCCR and other relevant acts. So what is this 2015, why we are talking and why assembled here? The triggering point, as also has mentioned by the earlier speaker, is about this globalization of the world, liberalizations have taken place in recent times. In fact, it was mentioned about also about the ease of doing business. In 2020, as per the ranking, world ranking, India stood, I think, 63 out of 190 countries. If you look back in 2014, it was 142. India was aspiring to be a world economic powerhouse, and with the onslaught of these new economic activities which was coming in view of this liberalization and globalization, the challenge was posed before how do we manage our judicial system. Therefore, this 2015 is an offshoot of that general endeavor of India to integrate ourselves with the global economy in a much more smoother manner. In fact, the E-Committee, and Honorable Justice Mukherjee also here, he has been a veteran also. I remember meeting him very frequently in Supreme Court, having this constant discussion about this E-Committee. In fact, E-Committee also contributed to a great extent in this, in reducing this, in ranking up of doing business, ease of doing business. And it is basically trying to streamline the law. There is nothing actually, if you see the provisions of the Act, these are basically being practiced by courts, in many of the courts who are very, very particular. Many courts, they would insist in timeline of filing the submission. In fact, this board management system, which we see for the first time mentioned in the Act, actually it was been practiced earlier. But we wanted to emphasize that aspect. In fact, court management, there's nothing new about this Act. We have been advocating this court management system in all other proceedings also. Why only for commercial courts? But it was felt that in commercial disputes again, it was much more important because the effective, not only effective, but speedy resolution of commercial dispute lies in the core, in the core of our economy, that is evolving and developing economy. Therefore, this, in fact, is case management system, this provision of case is something which I think both the lawyers must also insist, because This is basically a gathering of the lawyers, not much of the judges. So for judges, of course, there will be another occasion to discuss how we manage ourselves. But for the lawyers, since there is a specific statutory provision, you can insist upon the judge. See, the judges themselves also, see, two things are there, I see. Unlike in commercial courts are maximum, in Delhi there are 49 courts, if I am not mistaken. In Bangalore, 10 courts, and in Kolkata, 2 courts, and Mumbai, 6 courts. So Delhi has the highest number of commercial courts functioning. And Delhi is uniquely positioned to lead actually. Therefore, the members who are practicing mostly in commercial courts also have not only responsibility, but also it can be a right to the remaining rest of the country in evolving this commercial practice. Now, this case management is so important in my, it goes to the heart of the matter. Unlike other procedures which are basically emphasis, reiteration of the various provisions of law, but case management is something thereby we can stick to our timeline. So important. Yes, questions have been asked whether we can actually complete this proceeding, execution case, for example, it has to be done within 6 months or something like that. 1 year. Now, we know there are still so many execution cases pending in Supreme Court. And how many years old? 20 years old, 30 years old. I mean, this is something, one of the greatest, I think, problem of Indian judiciary is to how to lessen this time period. Especially, it's sometimes people say it's easy to get a decree than to execute it. I mean, this is literally true. And you can't see, the commercial courts doesn't exist as an island. This whole jurisprudence and all this legal system of commercial courts does not exist as an island, autonomous functioning. It's part of the legal system. Therefore, yes, there will be challenges whether we are able to keep up to the timeline as per the court management provision. Yes, but then the fact that this law specifically gives an emphasis on this aspect is something which we must all take care, and there is a statutory right. Earlier, it was left to the discretion of the judge how to manage his own court. But now it is a statutory right. Not only an obligation to the court, but also the right of the parties to insist that yes, Your Honor, why you are not abiding by it, why you are not insisting upon it. Along with this, I feel that the provision for imposition of cost is important because India is very liberal. I see Indian courts are very, very liberal when it comes to, I hardly see the cost being imposed. All kind of adjournments are sought, we liberally give. When I see Justice Sadri appearing before me, this problem, okay, granted. So this, it also shows kind of very cordial relationship between the bar and bench, but at the cost of the litigants. The litigants, they said, why it is being adjourned? They won because they have paid for it also. It's not that the parents of the lawyers, this is as illegal as services matter, or it's because the litigants pay for that service of the lawyers. So cost is something I realized when 1990 I had been in London for 6 months. At that time there was a post-court young lawyers course. It was sponsored by the Bar Council and the British Council. My brother Justice Sachdev said, he was with me also together. He's in Madhya Pradesh. And we were attached to some chambers, and we went to some courts. I went there with the lawyer who was assigned to me, and I wanted to see, but then unfortunately the case got adjourned. Immediately the judge passed the order. How much you expended for coming from London to I don't remember the name of the place. We had to travel by train by about an hour or so. This is the cost. This is the ticket. This is adjourned allowed on payment of this immediate, without any asking. But we don't normally do it here. It is something the lawyers have to insist. If you are coming and if you see that your opponent is not coming, you must insist upon the judge. And judge has an obligation to pass certain court, and that's reasonable cost. I mean, it's not exorbitant. That's what Section 35 also says. Cost, and explanation says cost means reasonable expenses. So it can't be very exorbitant. So this is something. Ultimately, what I'm trying to point out is that apart from the various provisions of this Act which will be discussed, the experts are here, but this is something that goes to the core, because ultimately what we are trying to see is that the disputes must be resolved at the earliest. And how do we do it? These are some, of course, provisions are there. Yes, there have been some issues that have been flagged also. I just mentioned that how do we narrow down a definition of commercial disputes. I think it will create much more a problem. I feel that let it be there. I think we should see the pecuniary jurisdiction, because you see some of the disputes runs into crores, and billions and billions of rupees, and some are few lakhs rupees. So why you burden the district judge level judges with that case? So I think it should be segregated. It should be, because the Commercial Courts Act also provides for appointment of commercial judge, court judge below the rank of district judge. If you see, therefore that can be handled by senior division judges also. So why unnecessarily burden those commercial courts who are already burdened with these huge stakes? So I think we can segregate those cases which are of a lesser amount to the case courts which are at the senior division or grade 2 level. This case management has been also I have mentioned already, and also imposition of course I think very important. Mediation, yes. As I mentioned also, in ancient times commercial dispute used to be resolved through mediation, arbitration. And mediation is becoming very important. We have already enacted this Mediation Act of 2023. And it specifically mentions about this provision of mediation under this Commercial Courts Act. Mediation is something, yes, many are not still prepared because of the fact that we don't have the pool of skilled mediators. Obviously, the mediators can't be just ordinary person who are walking on the street or good mediator, because they can be good mediator for family disputes, they can be good mediator for other disputes, natural disputes, but commercial disputes mediation would require a specialized knowledge. That is how, I want to say that what are the strategies to be adopted by the lawyers? I think we should start learning the art of mediation also, because then we'll have a pool, special pool of lawyers who are trained in this, not only the commercial laws, but also mediation. Because the statute itself provides, it's not an option, it's a mandatory. I think we should go for a pre-litigation mediation. This is something which we must, and the businessmen who are normally are in disputes, they don't want to spend time. If they think that there is an honorable exit, or it can be resolved fast in a much speedier manner with mediation, why not? They would certainly love. But then we must have that mediators who are trained in this. It's very important. Therefore, this is something which I would request the organizers to start training program for mediation. And this, because it's a skill which is, there's a specialized skill for mediation which has to be imparted. It can't be just gathered just by watching the proceedings. So that skill has to be. Therefore, I feel that like we have this arbitration bar of India, because they are now slowly having a specialized group of lawyers who are specializing in arbitration. Why can't we have that also? Commercial bar of India or something like whatever. And then they'll specialize in these areas of mediation and also the normal laws of the. Yes, and yes. Pronouncement judgment is, of course, it's possible. I think we should insist upon, because commercial disputes are basically based on documents. Because these are not, I don't think there will be any oral say agreement and coming for a huge dispute. Because I don't see that these are theoretical possibilities, but practically all the disputes involve documents. Because every businessman, every company, they have proper documentation of all their dealings. Therefore, there is no reason why we should not be able to take advantage of this. Because if you are claiming certain right, relief on the basis of documents. That's what will be difficult on the part of the judge also, on the basis of the documentation to be able to deliver summary judgments as and when the situation arises. That's what the importance of discovery is. All these are something which can be put to the optimum use by the lawyers. These all are part of the transactions. Yes, these are some ideas I thought I just discussed. As far as the amendments are concerned, it's again trying to be much more specific. There's nothing again, I don't see any new concept being introduced. They're trying to streamline in a much more and making it more stringent. What I see, for example, in the 24, this new amendment, proposed amendments, the commercial, there's a use of also, there's one thing important also, use of this VC, virtual mode. This is also very important because in today's world, most of our business dealings are also done virtual mode also. And therefore very important, the lawyers, we keep a proper documentation and record of these, our all virtual proceedings. The audio, video, electronic means includes use of any communication device for the purpose of video conferencing, recording of evidence. Companies, they operate not in a particular place, they have overseas offices, offices all over the country also, or the world also. And the person who is required to be examined, maybe the use of VC can be. Now this has given, what I'm trying to say is they have been given, though VC is being used in other proceedings also. We allow proceedings in the Supreme Court also. Lawyers are coming, arguing, we have mediation proceeding also, they will be allowed to VC. But here, the specific provision, we must invoke is try to use optimum, we make the optimum use of the provisions, which is a statutory provision. That is why we say that, I say that we must insist upon the judge that please invoke these provisions of law for effective and speedy proceeding. The VC should be used to the maximum for examining witnesses who are maybe outside the country. Through VC means you can always examine, cross-examination, all can be, and electronic communication also. These are all important. What I'm trying to say is that all this use of IT is something which has been put to maximum use in the Act. And we also know that in commercial transaction disputes, all this will come at a great help. And therefore, also important is that the lawyers also should be well trained in this IT. This is something very important. In fact, not only in commercial courts, I think it is going to be a requirement, I would say, for any lawyer entering the system. A lawyer, he may also become a judge. A judge will have to decide many of the disputes involving digital evidence. How many of us, frankly, I don't know, because in India, Delhi, Bombay, Calcutta, hospital cities are much better equipped. But I see that in many of the rest of the country, the judges are not equipped to deal with it. Because we are going to decide disputes which involves intricate technical evidence. Unless we ourselves are equipped with that knowledge, how do we decide? So that, in fact, that is why I remember this Commercial Courts Act, also Section 20 also provides. Again, judges are undergoing judicial training. All the high courts and the Judicial Academy imparting training to the judges from time to time. But there is a specific provision under Section 20 of the Act which says that the training and updation of knowledge should be a regular practice. So it's again a statutory provision. It's just not a desirability. And of course, the government has a responsibility to improve the infrastructure. Again, there's nothing new about it. All over the country, we have serious issues of judicial infrastructure. In the Supreme Court, I remember there was an attempt to have a infrastructure council or something like that. The government of India did not agree to it. But here, the government, by this enactment, the government has entered itself under Section 19 of the Act. It is responsible to the government to provide the necessary infrastructure for the proper function of the commercial courts. Therefore, you have a right to invoke the provision again. Unlike the amorphous right vis-a-vis other courts. You can't file a, perhaps you can file a PIL, but you can't file a petition before the court or Supreme Court saying that yes, this family court or this or POXO court or this fast track court, they are not functioning properly, therefore government should be directed to provide necessary funds for it. But here you have a right, Section 19 provides you because it is their obligation. So these are, I think, what I'm saying is this 2015 commercial code, when I see, it is something very revolutionary in a sense that many of these problems which we face in the normal judicial proceedings are sought to be streamlined by giving a statutory mandate. That is what I feel very important aspect of 2015 Act. Though the problems are not new, the law is not new. They have been all there throughout, but they have streamlined and put in one statute. I'm sure at some point of time there is going to be a merger of Arbitration Conciliation Act also with this mediation, because mediation, they're going to be, as we go together, there will be more and more interface between these three acts: Mediation Act, Arbitration Conciliation Act, and the Commercial Court, because they operate in a more the same domain. And we are going to see more and more, and for which again I mentioned again, the knowledge, the technical knowledge, the digital knowledge is going to provide a basic platform, not only for the system, but for also approaching and how to deal with these issues. I think I have taken much of a time. I thought this is something which came in my mind, which I could share. Thank you very much for this.